Probation, to me, in a felony case, really of any kind, when someone is here unlawfully, doesn't make any sense. This is Mr. Coleman.
Yes, Judge.
You didn't have to participate if you don't want to.
Good morning, sir. Are you Vishal?
Yes, ma'am.
And this is cause number 25 DCCR 0507. Mr. Vishal was previously in court, entered a plea of guilty to the state jail felony offense of criminally negligent homicide. This was unagreed. The plea was. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge.
State has, Judge.
Are there any additions or corrections to the report?
Not from us, Judge.
Not from the state, Judge.
All right, then.
This is one of those cases where nobody walks away feeling like justice truly won. The defendant isn't denying responsibility. He pleads guilty immediately. No trial, no excuses. And yet, someone still lost their life. A 16-year-old who never even got a chance to grow up.
Mr. Birch, you may proceed.
Judge, we're asking the court to consider probation. This case is unique, I would argue, for a variety of reasons. First and foremost, this court is very familiar with me and my proclivities. I would try this case 100 times out of 100. When I walked in to talk to him the first time, he said, I want to accept responsibility. That almost never happens. He didn't shirk his responsibility. He didn't. We can talk all day about the fog. We can talk about the Tex dot needs to get their act together with the shoulders on the highway, whatever we want to talk about. He wanted to take responsibility. And he said it from the first day. When was the last time you ever saw me come in and plead on the first hearing, plead guilty to a serious offense like this? Never. He wanted to do that. That was him wanting to do that. And so from that standpoint, it's a unique case. The other reason it's a unique case is there's no aggravating factors here. He's not intoxicated, he's not on his phone, he's not doing anything other than driving his vehicle. Now, what happened to these people in the end result is absolutely tragic. And again, he's taking full responsibility for that. But I will tell you, Judge, if he'd had 5 more seconds notice, he wouldn't have been able to stop the vehicle. It had 10 more seconds notice. He wouldn't have been able to stop the vehicle. He's doing the speed limit. He's driving on the highway, and there are vehicles on his left and behind him, and there is a stopped vehicle on the interstate. I mean, there's not a scenario in which maybe the injuries are less, but there's not a scenario in which this accident does not happen. And so, again, he's saying, I should have been more careful, I could have done other things, I could have fixed this. And the way he's saying that is with his plea, and also his statements here. He expresses deep remorse, he struggles to sleep at night, he feels guilty about what happened to these people. And again, there's nothing redeeming about the outcome for these decedents, these victims. But the reality is, this is a situation that is a terrible, tragic accident. He is trying to take responsibility. I think that is, again, at least from my standpoint, is somewhat unique. And I'm asking the court to at least consider.
When defense attorneys talk about tragic accidents, what they're really asking is for mercy without denial. He wasn't drunk. He wasn't texting. But criminal negligence doesn't require evil intent. It only requires a moment where care should have been higher and wasn't.
The distinct possibility and the option here that you have to grant him deferred adjudication probation, he would give up his driver's license, he'll give up his CDL, he'll do whatever the court orders in order to comply with probation. But putting him in the state jail for another year and a half is not going to fix anything. It's not going to make it any better for these decedents. It's not going to make it any better for their families. It's not going to do anything to anyone other than just cause him to not be out in the world for a year and a half, and that's it. And so this court could supervise him, this court could oversee his continued acceptance of responsibility, and also protect the public at the same time. So we're asking the court to consider doing that, and that is our request.
All right, thank you. Mr. Coleman?
Thank you. I'll be brief.
I'm sorry. Are there any holds?
Probation sounds reasonable on paper. Give up the CDL. Give up driving. Let supervision replace incarceration. But the question nobody wants to answer is this: what does accountability look like when the harm is permanent?
I'll be brief, Judge. Mr. Gertz and I agree on one thing, that I, like him, would try this case up, as he puts it, 100 out of 100 times. Myself, Judge, this is no accident. This is pure negligence, as it is the definition of negligence. I'll spare the court. I didn't showing the court the video. The tractor trailer that this defendant was operating today was equipped with dash cam, or a version of dash cam video that shows that the vehicle that he struck was not stopped. It was traveling at a slower speed with its hazard lights on, but it wasn't stopped. There was no fog. The conditions were clear, and there was no cars on the other side of this tractor trailer rig, preventing it from even changing lanes. I have the video. The court, if it desires, can certainly watch the videos. Short clip. But Judge, I take issue with that recitation of how this all went down. I'd like to offer State's Exhibit 1. It's a certified copy of FBI records indicating that
Make
this
that
defendant...
2.
Make it 2?
Because States 1 would have been the plea papers.
All right.
And we have no objection to it.
Then the prosecution drops the hammer. Dashcam footage. Clear weather. No stopped vehicle. No fog. No traffic blocking a lane change. This isn't about bad luck anymore. It's about preventable decisions in a vehicle that can kill.
It indicates, Judge, that this defendant illegally entered this country and he's a national of the country of India. Judge, I'm not here to make some type of a political statement or commentary. I'm just simply saying that it is a violation of federal law to enter this country illegally. And Judge, like any other violation of law, in any other case, you can take that into consideration in sentencing this defendant. I'm asking you to take that into consideration in this case, Judge. So here's States 2.
No objection. States 2 is admitted.
Judge, I also offer State's Exhibit number 3, pursuant to a business record affidavit that's been on file. It is a photo of the victim in this case, Judge. 16-year-old victim in the short obituary of her. Your Honor.
No objection to it.
States 3 is admitted.
Judge, she was 16 years old, Judge. She had, at the dawn of her life, she'll never get to graduate high school, get married, do the things that people do. Judge, you can say today by your verdict just the amount of damage and harm this defendant has caused.
And this is where things get uncomfortable. Immigration status enters the room. Not as politics, but as part of sentencing. Whether people like it or not, judges are allowed to consider it. The law doesn't pause just because the topic is sensitive.
Due to its negligence. I'll conclude with a couple other things, Judge. This defendant went on to continue to live his life as business as usual in California after this accident, while the investigation played out. After the investigation and the indictment, it took some effort on the part of our office in conjunction with the U.S. Marshal's Office to track down and locate this defendant. I'm not saying he was intentionally hiding or absconding. I'm simply saying it took a lot of effort by the federal law enforcement authorities to track him down, Judge. And also this business about this name and the alias name, and whether or not he goes by no name given or goes by Bishaw. Again, the court can infer whatever the court wants to infer about why an individual would illegally enter this country and use at least one or maybe 2 different aliases, Judge. I'm asking for the max, and I am frustrated at the fact that all I can ask for is 2 years in this case, Judge. But I'm asking for the 2 years. In this case, I think this case warrants 2 years. Judge, if the court is not inclined to give it 2 years, I'm asking that the court deny the discretionary jail credit pursuant to my motion that I filed under Article 42A559 of the Texas Code of Criminal Procedure, Judge. And lastly, the family.
Say what you just said again?
It's in my motion that I filed, asking that the court deny the discretionary jail credit for state jail offenses.
Oh, okay.
It's 42A559C of the Code of Criminal Procedure, Judge.
Okay.
And lastly, Your Honor, the family's here. for whatever, for what that's worth, Judge. And I believe that the mom, the mother of the deceased, would like to make a victim impact statement.
Thank you, Mr. Coleman.
A photo of a 16-year-old victim doesn't need to be shown to be felt. One sentence is enough. She never graduates, never marries, never lives the life she was supposed to have.
So it's my understanding that there is, at this point, immigration hold on Mr. Vishaw, correct?
Yeah, that's my understanding too, Judge.
Okay. So even though it's likely for him to be deported because he's here unlawful, you're asking for probation?
Well, Judge, there's not really another option, right? So I guess the question is, given the current status of our immigration situation, I have no idea how ICE is going to handle this. What an ICE hold means is that if you give him probation, they've got 3 days to come pick him up. And if they don't come pick him up, then he's placed on probation. And what the court can then do is supervise him unless and until the federal government comes and deports him or attempts to deport him. The kind of alternative to that is he can sit and sleep on a cot that we're providing and eat food that we're providing and then be deported at the end of that. With a conviction or a deferred adjudication, he's going to get deported at some point anyway. So it doesn't really, the court, I'm not trying to be difficult, but this court's decision is not going to change the likelihood of his deportation, because a deferred will count as a conviction for deportation purposes. A conviction will count as a conviction for deportation purposes. So, again, we're asking the court for probation because of his acceptance, again, of responsibility here in this case.
All right. And I appreciate the acceptance of responsibility. I do. I appreciate, and I'm sure the family appreciates, not having to go through a trial and see what they had to live through over again. And so I will take that into consideration.
You can hear the judge wrestling with this. Probation only works if the court can actually supervise you. And if deportation is inevitable, probation becomes symbolic, not protective.
Probation, to me, in a felony case, really of any kind, when someone is here unlawfully, doesn't make any sense. And again, I'm with Mr. Coleman. I'm not here to make a political statement on any of this, but if you're here unlawful and you've committed a felony offense, it just doesn't make sense that I would put somebody on probation where they're potentially still a, I don't know, threat to the safety of our citizens. And the no name thing gives me some concern. Also, I feel like that is just potentially an attempt to avoid probably some issues with immigration and some issues with potentially this case. So what I'm going to do, again, I appreciate, and I'm sure the family appreciates, not having to go to trial. But I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of criminally negligent homicide, sentence you to a term of 20 months in the state jail prison. You will receive, I will give credit on that for any time that you've been in custody that the law gives you the right to receive. With regard to the state jail credit, I leave that up to the state jail authorities, and I'm going to deny the motion to deny that credit. That will be up to Mr. Vishaw in state jail. With good behavior, he'll get that credit just like everybody else. So I'm not going to deny that. It's based on, always has been based on how you behave in the state jail prison. And so just to deny that, it goes against the nature of that rule and that law, so I'm not going to do that. I'm going to hand you the trial court certification that shows there was no agreement, which means you do have a right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that to determine what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Gertz. Good luck to you, sir. Thank you, Mr. Coleman, Mr. Gertz. Okay, did Ms. DeLage go?
Judge, there was a matter of the victim.
Oh, I'm sorry. Yes. If y'all will have a seat. Mr. Kimler, can you move for a second so they can use that table? You can just have a seat over here and we'll go off the record for the victim impact statement.
20 months. Not maximum. Not probation. Something in between. And maybe that's the most honest ending this case could have. Accountability without pretending prison restores what was lost. Just as he doesn't feel victorious, it feels heavy.
Mr. Coleman, yep. Good morning. You're Jacoby and Dorsey. And Mr. Dorsey, in cause number 25 DCCR 1896, you're charged with a second-degree felony offense of manslaughter from November 17th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in the institutional division of the Texas Department of Corrections.
Your Honor, it's my understanding he has a prior felony conviction that's enhanced to a first.
That is the way, well, it's not indicted that way, Judge, but I will be seeking a repeat offender. I'll be filing a repeat offender notice.
I wrote first degree on there.
Right.
Because, and there's some confusion. He also explains that his underlying conviction is on appeal, I believe. That's what he tells me. So I told him I would check with the court to make sure that's right. If it's 5 to 99 or 2 to 20, because I didn't know the status of all the other stuff.
If it's on appeal, then potentially that could be an issue with regard to it being a final conviction. So what can happen is if that appeal, once it's complete, and if they affirm that verdict and that conviction, and at that point, this would then potentially become, for punishment purposes, enhanced to a first-degree felony if that conviction becomes final. And I don't really know, the final conviction date, if that creates an issue because of the appellate process.
I'm not sure, Judge. I'm happy to look at it.
Judge, and I don't know the answer to that question.
Yeah.
But being familiar with this defendant, I tried him next door, involving several co-defendants. Ms. Duchamp and I did several years ago.
Okay.
He actually was on probation over there for cooperating with us for aggravated robbery involving adjacent murder. He received 30 years on that revocation. I went back and double checked, and I'm sorry to interject, double checked that date. That hearing and that revocation was before this offense date. He had actually gone to Jefferson County Jail and was waiting on his 30-year sentence at TDC when this offense occurred in the jail.
And with that being said, Judge, the state will also be seeking, to the extent the law will allow us, to stack any sentence in this case on top of that 30 years sentence.
He's already filed the paper for that.
That 30-year sentence, though, is the one that is on appeal.
Possibly on appeal.
Okay, so I guess that's the
Our
question.
position would be that the decision that was made that was then subsequently
It would go back to the
affirmed,
conviction
go back to
date.
that date, yes.
That would tend to be what I would think, but we would obviously have to do a little bit of research to double check. And so I think that the most thorough way to do this is for you to understand that if that conviction is affirmed by the Court of Appeals, then it would appear that the conviction date then goes back to when that original conviction was, which was prior to the date of this offense. And therefore, it could enhance your punishment to that first-degree felony. If you go to a jury and they find that you're guilty and they find that conviction true, which means your minimum punishment would be 5 years instead of 2, up to 99 years or life in prison. Do you understand? In addition, if it's affirmed prior to any trial date or anything like that, and you're found guilty, Mr. Coleman can ask that any sentence that a jury gives you be stacked on top of or run consecutive to that 30-year sentence.
He's already filed that paperwork, Judge.
Okay, and that decision would be up to the court or up to me. So if you're found guilty, that could be a potential punishment in addition to yours, is that whatever the jury gives you, I could stack on top of that 30-year sentence. Do you understand all of that? I'm sorry, speak up. And I have a plea bargain rejection that you've signed here with Mr. Parker that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on just the count of manslaughter itself for a 20-year term in the institutional division. And that would be to run concurrently, that would be stacked.
That would be stacked, Judge. At least that's the offer as it stands. The state will entertain a counteroffer.
Well, I mean, that's,
I
okay.
get it, Judge.
I can't, don't know why anybody would
No, I
accept
get
that offer. So, do y'all want to visit a little bit more about this?
I can
and
talk to him
before
and
I
see
put
if-
it on a trial
I
docket?
can talk to him about.
Let me hold it.
possibilities.
Y'all visit a little bit about that before I take this to the trial docket. Good morning. Are you Jeremiah Branch? Good. And Mr. Branch was previously in court, entered pleas of guilty in cause numbers 25 DCCR 1382 and 1385. And I received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor. Yes, sir.
Any additions or corrections?
No.
All right, Mr. Branch, I am going to find that you entered your plea of guilty in each case freely and voluntarily. In cause number 25 DCCR 1382, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made and defer all proceedings and place you on probation for 10 years. You're ordered to pay a $500 fine in that case and to follow all of the rules and conditions. And I'm going to go over some specific ones in just a minute. And then in cause number 25 DCCR 1385, also find sufficient evidence to find you guilty, but follow the agreement that you made and defer all proceedings and place you on probation for 10 years. You will also be ordered to pay a $500 fine in that case and to follow all of the rules and conditions of probation. A couple of specific things that you're going to be required to do. One is to enter and successfully complete the JCDI program. That's an outpatient intensive program for drug treatment. So it's to be able to give you the tools to stop using whatever drugs you're using, stay clean so that you can be successful in your probation. Also, I know you've already gone and I think have some relationship with Spinal Tap, and you're going to be required to continue all of that. That's part of your probation. Obviously, that's something that you need to make sure you also can be successful, okay? If you do everything you're supposed to and successfully complete these probations, this is an excellent opportunity today because you do not have these felony convictions on your record. And at the end of the probation period, if you're successful, the cases will actually be dismissed and you'll never have convictions on your record. The other side to that, though, is if you violate any condition of probation, you can be brought back into court, you can be found guilty in each case, and you can be sent to prison for anywhere between 2 years and up to 20 years. Do you understand? All right, in each of your cases, I'm handing you the trial court certifications. That shows that these were agreements that I followed, and so you have waived your right to appeal. I will sign dismissals in cause numbers 25 DCCR 1383 and 1384 as part of that plea agreement as well. All right, good luck to you, sir. You can go back with the bailiff. Good morning, are you Raul Carino? And Mr. Carino's case is set for trial to begin with jury selection this coming Monday, and what is the announcement?
Your Honor, the state is ready for trial, although there's a witness that I really do need to put on our case and is unavailable for trial. So,
Well, you can't be ready and need a witness too. So either you're ready or not,
we need that witness, Your Honor.
okay?
It's the lab animal, DNA lab animal.
Okay, and she'll be out all week?
What she told me was she was unavailable to travel and testify this coming week.
Mr. Matuska?
Your Honor, I spoke about this already with Mr. Nichols, I understand.
Okay,
And whatever scheduling that needs to be done, I can accommodate the court.
okay. Obviously, since Mr. Carino's in custody, I want to try to get it tried as quickly as possible. I'll reset it off of this trial docket to the next available trial docket. If there's any change, and that's obviously before any change that's going to take place, just let me know and we'll get somebody that can jump in as quickly as possible. Mr. Carino, I'll get your case set as quickly as possible, but I'm going to give the state one reset so that they can try to get that witness, okay? All right, you can go back with the bailiff.